This is the LWA Criminal Law Audio Outline. General concepts. Jurisdiction. Jurisdiction is where a crime or a result of that crime happened. Classification of crimes. Classification of crimes includes felonies and misdemeanors. Elements of a crime are 1. Actus reus, 2. Mens rea, 3. Concurrence. Actus reus. The actus reus of the crime is the physical act or omission of the crime. It is not reflexive movement or unconscious movement, such as in sleepwalking. It's not conduct that is not the product of your own volition. For example, you were pushed. Actus reus and omissions. Omissions are wrong where there is a duty to act. Duty is created by 1. Statute, 2. Contract, 3. Relationship between the parties, 4. Voluntarily assuming a duty of care and then failing to adequately perform it, and 5. The defendant's conduct created the peril even if accidentally. Mens rea. Mens rea is the mental state, the guilty mind. There are 4 types of mens rea to know. 1. Specific intent. 2. Malice. 3. General intent. 4. Strict liability. You must memorize the intent level of all crimes and state it clearly in an essay. Specific intent. Specific intent requires doing the act with a specific intent or objective. Existence of specific intent cannot be inferred. Specific intent crimes get additional defenses that other crimes do not. Voluntary intoxication and mistake of fact, where the mistake is unreasonable, is a defense for specific intent. Specific intent crimes include attempt, solicitation, conspiracy, first-degree murder, assault, which is the specific intent assault, larceny, robbery, burglary, forgery, false pretenses, and embezzlement. Malice. Malice requires a reckless disregard of an obvious or high risk that the particular harmful result will occur. Less restrictive than specific intent. Gets the same defenses available to the general intent crimes. Malice crimes include second-degree murder or common law murder and arson. General intent. Awareness of all factors constituting the crime. It includes the defendant is aware that he is acting in the prescribed way and that any attendant circumstances exist. Certainty is not required. It is sufficient that he is aware of a high likelihood they will occur. A jury may infer the required intent from the doing of the act. Doctrine of transferred intent. The defendant intends the harm caused, but to a different victim or object. Defenses and mitigating circumstances will also transfer. A person will usually be guilty of two crimes where this doctrine is invoked: the attempted crime against the intended victim or object, and the completed crime against the actually harmed victim or object. This is heavily tested. Applies to homicide, battery, and arson. Strict liability, also called a public welfare offense. The defendant is guilty merely from committing the act of the crime. We do not care about the defendant's mental state. Common examples are statutory rape, bigamy, selling liquor to minors. No defenses to strict liability crimes except insanity. Analyzing statute. Criminal law MBE questions largely require you to analyze a statute. Check the language carefully for the mental state required for each element of the crime. Model Penal Code. Different categories of intent. Purposely. The defendant acts purposely when her conscious object is to engage in certain conduct or cause a certain result. Knowingly. The defendant acts knowingly when she is aware that her conduct is of a particular nature or knows that her conduct will likely cause the result. Knowingly equals willful. Recklessly. She knows of a substantial and unjustifiable risk and consciously disregards it. Negligence. She fails to be aware of a substantial and unjustifiable risk where such failure is a substantial deviation from the standard of care. Accomplice liability. This is a theory, not a crime. The defendant must be aiding, abetting, counseling the crime. Active aiding is required. Mere presence is not enough. Liability is for the crime itself and all other foreseeable crimes. The defendant is guilty as an accomplice. Defenses to accomplice liability. Withdraw. Repudiate the encouragement. Retrieve materials. Alternatively, notify authorities or take some action to prevent the commission of the crime. Must also be before the chain of events leading to the commission of the crime becomes unstoppable. Accessory after the fact. Related to accomplice, but this happens after the crime. It is helping someone to escape. Not liable for the crime, but for a separate lesser charge. Solicitation. Inciting, counseling, advising, urging, or commanding another to commit a crime with the specific intent that the person solicited commit the crime. It is not a defense that the person solicited did not agree to commit the crime. Doctrine of merger. At common law, the defendant could only be convicted of the felony if a misdemeanor merged with it. Modernly, the merger doctrine has been abolished except for solicitation. The solicitation merges with the completed crime. Still address solicitation on an essay, though, and say that it merges with the completed crime. All attempts merge with the completed crime. Conspiracy. Conspiracy requires 3 elements. 1. Agreement between 2 or more persons. 2. Intent to enter into the agreement. 3. Intent by at least 2 persons to achieve the objective of the agreement. You must know the majority-minority distinction and address it on an essay. The minority view of conspiracy, which is common law, is that the agreement is sufficient for liability. The majority view, which is the modern view, requires an overt act in furtherance of the conspiracy, but mere preparation is sufficient. Liability and defenses. Liability. The Pinkerton case. Each conspirator is liable for all crimes of the other conspirators if foreseeable and in furtherance of the conspiracy. Defenses. No impossibility defense can only withdraw from liability for future crimes, and there's no merger. Attempt. Specific intent of a substantial step in the direction of the commission of the crime. Mere preparation is not enough. Defenses to attempts include factual impossibility, which is not a defense. Legal impossibility is a defense under majority rule. Abandonment is not a defense after substantial steps have been taken. Homicide. The intro statement for homicide must be memorized. The intro statement for homicide is: homicide is the unlawful killing of another human being. Homicide consists of murder and manslaughter. Murder is the unlawful killing of another human being with malice aforethought. Malice aforethought consists of one of the following 4 states of mind. 1. Intent to kill. 2. Intent to commit great bodily harm. 3. Reckless indifference to an unjustifiable risk to human life. And 4. The intent to commit a felony. Because the defendant has committed an act which resulted in the victim's death, he has committed a homicide. First-degree murder. No uniformity in the states. Committed with premeditation and deliberation. This requires that the defendant reflected on the crime, but it can happen in an instant. Second-degree murder. All other murder is second-degree murder. That is, it is not committed with premeditation and deliberation. Voluntary manslaughter. A killing that would be murder but for the existence of adequate provocation. There is no malice aforethought. Adequate provocation exists if 1. Was a provocation that would arouse sudden and intense passion in the mind of an ordinary person, causing him to lose self-control. This is objective. 2. The defendant was in fact provoked. This is subjective. 3. There was not sufficient cooling time between the provocation and the killing for passions of a reasonable person to cool. This is objective. And 4. The defendant in fact did not cool down. This is subjective. Voluntary manslaughter, imperfect self-defense. Some states recognize this defense where murder is reduced to manslaughter. For one, the defendant was at fault in starting the altercation, or two, the defendant unreasonably but honestly believed in the necessity of responding with deadly force. Involuntary manslaughter. Involuntary manslaughter is committed with gross criminal negligence or during the commission of an unlawful act. This can also be called the misdemeanor manslaughter rule. How to address homicide in an essay. You must think like the prosecutor and the defense attorney, to think of all of the different types of homicide and analyze them, except felony murder. Felony murder. Felony murder is committed when any death caused in the commission of or in an attempt to commit a felony is murder. Malice is implied from the intent to commit the underlying felony. Felonies must be inherently dangerous. For the test, you must use BARK. B-A-R-R-K, BARK. Burglary, arson, rape, robbery, kidnapping, unless there's a statute provided that says otherwise. Do not write BARK in the essay. Include attempted crimes. Limitations to the felony murder rule. The defendant must be guilty of the underlying felony. The felony must be distinct from the killing itself. Death must have been a foreseeable result of the felony. Death must have been caused before the defendant's immediate flight from the time the felony ended. Once the defendant reaches a place of temporary safety, liability ends. Know the agent theory versus the proximate cause theory. Limitations of the felony murder rule continued. Agency theory versus proximate cause theory. Agency theory holds defendants liable only for the deaths that are caused by the defendant or co-defendants during the commission or attempted commission of a felony, thereby excluding the deaths caused by third persons. Proximate cause theory holds defendants accountable for any foreseeable deaths that occurred during the commission or attempted commission of a felony, including the deaths of innocent bystanders caused by third parties and the deaths of co-conspirators caused by the police. Misdemeanor manslaughter rule. Same rules as felony murder rules, except the predicate offense is a misdemeanor or a felony which is not inherently dangerous, significantly less punishment than the felony murder rule. This ends the LWA Criminal Law Audio Outline.